Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover chapters 2 to 4. Chapter 2, Right of Accession. Section 3, Right of Accession with respect to movable property. Article 466. Whenever two movable things belonging to different owners are, without bad faith, united in such a way that they form a single object, the owner of the principal thing acquires the accessory, indemnifying the former owner thereof for its value. Article 467. The principal thing, as between two things incorporated, is deemed to be that to which the other has been united as an ornament, or for its use or perfection. Article 468. If it cannot be determined by the rule given in the preceding article, which of the two things incorporated is the principal one, the thing of the greater value shall be so considered, and as between two things of equal value, that of the greater volume. In painting and sculpture, writings, printed matter, engraving and lithographs, the board, metal, stone, canvas, paper or parchment, shall be deemed the accessory thing. Article 469. Whenever the things united can be separated without injury, their respective owners may demand their separation. Nevertheless, in case the thing united for the use, embellishment or perfection of the other is much more precious than the principal thing, the owner of the former may demand its separation, even though the thing to which it has been incorporated may suffer some injury. Article 470. Whenever the owner of the accessory thing has made the incorporation in bad faith, he shall lose the thing incorporated, and shall have the obligation to indemnify the owner of the principal thing for the damages he may have suffered. If the one who has acted in bad faith is the owner of the principal thing, the owner of the accessory thing shall have a right to choose between the former paying him its value, or that the thing belonging to him be separated, even though for this purpose it be necessary to destroy the principal thing, and in both cases, furthermore, there shall be indemnity for damages. If either one of the owners has made the incorporation with the knowledge, and without the objection of the other, their respective rights shall be determined as though both acted in good faith. Article 471. Whenever the owner of the material employed without his consent has a right to an indemnity, he may demand that this consist in the delivery of a thing equal in kind and value, and in all other respects, to that employed, or else in the price thereof, according to expert appraisal. Article 472. If by the will of their owners, two things of the same or different kinds are mixed, or if the mixture occurs by chance, and in the latter case the things are not separable without injury, each owner shall acquire a right proportional to the part belonging to him, bearing in mind the value of the things mixed or confused. Article 473. If by the will of only one owner, but in good faith, two things of the same or different kinds are mixed or confused, the rights of the owners shall be determined by the provisions of the preceding article. If the one who caused the mixture or confusion acted in bad faith, he shall lose the thing belonging to him thus mixed or confused, besides being obliged to pay indemnity for the damages caused to the owner of the other thing, with which his own was mixed. Article 474. One who in good faith employs the material of another in whole or in part, in order to make a thing of a different kind, shall appropriate the thing thus transformed as his own, indemnifying the owner of the material for its value. If the material is more precious than the transformed thing, or is of more value, its owner may, at his option, appropriate the new thing to himself, after first paying indemnity for the value of the work, or demand indemnity for the material. If in the making of the thing bad faith intervened, the owner of the material shall have the right to appropriate the work to himself, without paying anything to the maker, or to demand of the latter that he indemnify him for the value of the material, and the damages he may have suffered. However, the owner of the material cannot appropriate the work, in case the value of the latter, for artistic or scientific reasons, is considerably more than that of the material. Article 475. In the preceding articles, Sentimental value shall be duly appreciated. Chapter 3. Quieting of Title. Article 476. Whenever there is a cloud on title to real property or any interest therein, by reason of any instrument, record, claim, encumbrance or proceeding which is apparently valid or effective, but is in truth and in fact invalid, ineffective, voidable, or unenforceable, and may be prejudicial to said title, an action may be brought to remove such cloud or to quiet the title. An action may also be brought to prevent a cloud from being cast upon title to real property or any interest therein. Article 477. The plaintiff must have legal or equitable title to, or interest in the real property which is the subject matter of the action. He need not be in possession of said property. Article 478. There may also be an action to quiet title or remove a cloud therefrom when the contract, instrument or other obligation has been extinguished or has terminated, or has been barred by extinctive prescription. Article 479. The plaintiff must return to the defendant all benefits he may have received from the latter, or reimburse him for expenses that may have redounded to the plaintiff's benefit. Article 480. The principles of the general law on the quieting of title are hereby adopted insofar as they are not in conflict with this code. Article 481. The procedure for the quieting of title, or the removal of a cloud therefrom, shall be governed by such rules of court as the Supreme Court shall promulgated. Chapter 4. Ruinous buildings, and trees in danger of falling. Article 482. If a building, wall, column, or any other construction is in danger of falling, the owner shall be obliged to demolish it, or to execute the necessary work in order to prevent it from falling. If the proprietor does not comply with this obligation, the administrative authorities may order the demolition of the structure at the expense of the owner, or take measures to ensure public safety. Article 483. Whenever a large tree threatens to fall, in such a way as to cause damage to the land or tenement of another, or to travelers over a public or private road, the owner of the tree shall be obliged to fell and remove it, and should he not do so, it shall be done at his expense by order of the administrative authorities. And that is the end. If this audiobook has helped you, please comment down below, and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.